Good afternoon to all the distinguished dignitaries, respected faculty members, and dear participants. On behalf of KLE Law College, Bengaluru, I extend a warm welcome to the plenary session 2 of the two-day international conference on Goods and Services Tax Framework, Transforming Fiscal Federalism in India. The theme of this session is Constitutional Scheme of Distribution of Financial Powers. It's my privilege to introduce the chair of this session, Professor Anirban Chakravarti. Professor Anirban Chakravarti is a distinguished legal academician with over 18 years of experience across prestigious universities, including West Bengal National University and Maharashtra National University. He has also served as a professor and registrar at Damodaram Sanjeevaya National Law University and has been awarded with the prestigious Fulbright Fellowship in 2009. Now I request Dr. Yogesh sir to hand over a token of memento to Dr. Anirban sir. I now take the privilege to introduce our first speaker, Dr. Sairam Bhatt sir. Dr. Sairam Bhatt is a professor of law and co-director of the Central for Environmental Law, Education, Research and Advocacy at the National Law School of India, University, Bengaluru. He was a recipient of the Young Indian Environmental Law Fellowship 2003, served as adjunct faculty at Golden Gate University, San Francisco, and was awarded with the prestigious Fulbright Fellowship in 2010 as a visiting researcher at Georgetown University Law Center. Now, I please request Madhusudan sir to hand over a token of memento to Dr. Sairam Bhatt sir.
Thank you.
I now take the privilege to introduce our second speaker, Dr. Atmaram Shelke sir. Dr. Atmaram Shelke is a professor of law at Symbiosis Law School, Pune, with over 17 years of teaching and research experience. He holds a Doctor of Philosophy in Law with a specialization in intellectual property rights in cyberspace, a recipient of prestigious Hall of Fame Award 2025. Now, I please request Ms. Maimun ma'am to hand over the token of appreciation to Dr. Atmaram Shelke sir. With this, I respectfully invite the chair to kindly take over the proceedings of the session.
Thank you, ma'am. A very good afternoon to all of you. It's my delight to be part of a panel with such distinguished, eminent speakers on this subject. I will not take at all any time because this is not my, cup of tea. Tax law or constitution connected to that. So I leave on the experts. But being in the chair, whatever comments I have, I will make it at the end if time permits. But I think you should all get the benefit of hearing more from the experts who are essentially having the knowledge and the intellectual ability to explain the issue. So I start with inviting Professor Dr. Sairam Bhatt to make his observations on the topic of the session.
Good afternoon to everyone. We are short of time, so let me be brief with a couple of my observations on the topic of the conference. But before I do that, I think we have a tax expert right over here, Mr. Kodandaram. He is a fascinating person, to be honest, someone who is a keen learner all his life. Despite so many years of service in the government, he is a known trainer on GST to the Indian Revenue Service officers. So it's a great privilege to have you, sir, in the audience, and I hope that what I'm going to present will be evaluated and validated by you. Thank you so much for being here in the audience. I'm also joined by my colleague Pratik Kamath, who is a student of KLE and working with me right now. So I thought it's good to get him back to the institution. So thank you, Pratik, for helping me make this presentation. So let me be very quick on what I wish to speak today. Friends, I think if you are looking at tax, GST, or the fiscal federalism in India, there are many topics that one can speak about. So I have chosen a very small area that you all may be interested to know. And that area is how do state and center deal with taxation? Now, if you see today, there are quite mineral rich states like Odisha and Jharkhand for that matter, or Karnataka also for that matter. And interestingly, though these are mineral rich states, these states unfortunately are not doing very well economically or vis-a-vis GDP or otherwise. Have you ever wondered why? Have you ever wondered why? So interestingly, Jharkhand and Odisha are supposed to be among the backward states of India. Do you agree? At least say yes or no. Yes. Okay. But they're minerally very rich. So naturally, today's Iran-US conflict, you would have understood that if you're energy rich or mineral rich, you obviously will be very powerful. You'll always have a great economy. See, the Gulf regions, until they found oil, was a desert. But today it is probably a great oasis for investors to actually meet those investment. So the idea, friends, is about how are we looking at fiscal federalism vis-a-vis mineral and its taxation. Okay, that is the presentation that I have, and it's a very short and brief presentation. Now, when we look at fiscal federalism, friends, between the center and the state, especially on minerals, please note we can actually divide this kind of relationship with the center and the state into three categories. And I'll tell you why this is a little later. There was an era when the center and the state relationship on mineral fiscal federalism was docile. There was nothing much happening. The reason is because the central government and the state governments were one and the same. So we had Congress as the majority government in the center and Congress government in the state. So there was nothing major conflict that happened, and there was no demand that was happening. But in the 1990s, I think there was an idea of what we call as the cooperative federalism regime, where the center and the state decided that mineral resources belong to both the governments, and both the governments must actually try and take the benefits of the same. Of course, in India, as you know, that we have a lot of centralization approach. So the central government said, we will take 60%, the states can keep 40%. So there was cooperative federalism, and the states also understood and said, fine, because, you know, India in the 1990s did not have that much of an export market. We did not know who are going to buy Indian minerals. And 1990s, we discovered that China is our greatest importer, and so on and so forth. So cooperative federalism worked. But in the last 10 years, we have seen, especially in the mineral sector, please note, I'm focusing only on the mineral sector, that the federalism has become combative. And the center is actually fighting with states, obviously, because the central government may be of a different political ideology and the state governments may have different political ideologies. So you have states like Tamil Nadu, which are saying that the center is not giving enough and the center is making more money through these taxes of minerals, and the states are not getting their dues. So it has become very combative. And what happens when there is combative federalism is because, unfortunately, federalism is not working between the governments. It is for the courts to resolve that combative nature. So combativeness is good for lawyers. It's good news for us because it gets us business, it gets us cases, and it gets us a chance to do some legal opinion. So we have one legal opinion that I'm going to share with you, which is about combative federalism in this context. But before we go forward, I just wanted to ask some of you if you know the difference between these. Anyone? I know this is not a class, it's a conference, but I still don't like this one-way traffic. So quickly, anyone who wants to attempt the distinction between these, you can make an attempt. Need not be right. Even I don't know much. I researched only for this conference. Don't worry. Any idea? Is this important? It's very important, right? Now, friends, to understand it becomes very relevant. If I could have drawn, I would just tell you, let's assume, just imagine, friends, you have a 100 rupee note, 100 rupees, and 100 rupees is collected by the government, right? Now, in this 100 rupees, friends, please note, 80 rupees comes from taxes and duties to the government. Okay. 12 rupees comes from cess and 8 rupees comes from surcharge. Okay. Now, please note, cess and surcharge are very new concepts that the central government has introduced to actually increase its tax net. So what has happened is this so-called 20 rupees, that is a combination of cess and surcharge, in the last 15 years has added to the corpus of the central government. The real question is whether cess or surcharge has to be shared with the states. Whether cess or surcharge has to be shared with the states. The answer here is no. There is no such duty to share the cess or the surcharge. Because cess has a specific purpose. Surcharge is nothing but more and above the tax. So cess is for a particular component. It could be health, it could be education. That cess is used only for that purpose, right? And central government, on the constitutional scheme of things, has residuary powers, and they can actually design their own taxation process, including what is known as the service tax right now, which is adding to the central government corpus. Now, interestingly, out of the tax and duties, that 80% or 80 rupees in that 100 rupees, please note, usually there will be a finance commission, like the 15th Finance Commission, the 16th Finance Commission. They will probably allocate how much central government should keep, how much state governments could keep. Now, out of this 80 rupees, generally, friends, around 40 rupees or 41% goes to states and rest is kept by the central government. So who makes more taxes or who collects more taxes? Who has more money to spend on welfare schemes and other activities like infrastructure? The obvious answer is central government has that power. Now, the problem lies in this combative federalism. Right? States also want to do well. They have enough subjects on which they want to spend, but there is no money to spend. Do you know that there is one government in India today, a state government in India, which is unfortunately, it has gone bankrupt. It has told its employees that 6 months' salary will not be paid. Can you name the state government? You all started telling your own states. Good. It is fair enough, because probably the previous governments have already looted the budget and the infrastructure, and the new government is struggling, and that's why they go for borrowings. And as sir will tell you, that there is a limit on state borrowings that has been put by the Finance Commission as well. But friends, the answer is Himachal Pradesh. Right? The chief minister himself has made an acceptance. It is in the public domain. 6 months salary is not there. So which means if you don't have money even to pay salary, will you ever undertake any welfare progressive developmental work? Now, none of you told Karnataka. I'm happy. But I think the finance budget of Karnataka is also, I'm a Kannadiga, so it is also struggling. I think that is the appropriate word. Good. So I think the point here is, now if you are looking at tax, you understood what cess is, you understood what surcharge is. My question to you is, do you understand this term called royalty? Anybody? Quickly. If you're a student of intellectual property, I'm sure you can know what royalty is.
Amount paid on finalized product, how much we manufacture.
Excellent. So it could be based on a product value and its trademark, some kind of goodwill. Yeah. Wonderful. It is a consideration for licensing. Excellent point. Now, if you see, royalty becomes the most contentious matter in a case called MADA. Okay, in short, so that you can remember and write in the examination if there is one such question. So this case now has been decided by 9 judges already. Now, I'm literally worried about Article 141 and 142 of the Constitution of India, because Article 141 talks about precedent. Whatever the Supreme Court says has to be followed by lower courts, but the Supreme Court is not deciding anything. Whatever is decided is redecided. 9 judges have already decided the case on royalty on minerals. 9 judges. But we are not happy with these 9 judges. And that's why the government has filed a curative petition right now before the Supreme Court. So another 9 judges are now going to decide the MADA judgment. Now, the MADA judgment is an interesting judgment. Please note it. Why it is important is because it talks about royalties. Now, you must be saying, sir, tax is so much, cess is there, surcharge is so much. How much is royalty? Ladies and gentlemen, royalty in 2023 to 2025, government of Karnataka itself earned around 15,000 crores as royalty. From what? Mineral extraction. Please note, mineral extraction, thanks to a law called the 1957 MMRD Act, there is something called royalty for minerals. Now, the question was, this royalty is fixed under a central law, but please note, it is fixed by the central law, but the tax goes entirely to the state. So what is the conflict in this judgment of the Supreme Court? In the Supreme Court, the central government said once there is royalty on minerals, state governments cannot impose additional tax. Anyhow, that royalty money is going to state governments, right? Why should state governments additionally impose another tax? It is not right. Some state governments, thanks to the legal opinion received by some lawyers like us, they said, no, royalty is not tax. So apart from royalty, I can impose additional tax on minerals. How many of you think royalty is tax? None of you think. But Justice Nagaratna, who is from Karnataka, thinks, and she has opined in her dissenting opinion, which is 8:1 in the MADA judgment, she has said royalty in the Mineral Act is nothing but tax. And her dissenting opinion is now the reason for the curative petition being filed by the central government. Now, Justice Nagaratna's dissenting opinion, that's why I usually say to a lot of my friends, sometimes dissenting opinions are more interesting to read. Of course, the majority opinion is the rule of law. It is Article 141 of the Constitution, which is the precedent. But so many dissenting opinions have gone about to change the process and nature of law. Now, Justice Nagaratna's dissenting opinion is what I'm going to focus upon, because please note that is the same plea in the curative petition right now. The central government actually has taken whatever has been said by Justice Nagaratna. Now, Justice Nagaratna says, please note, there is some process or concept called double taxation. See, once on minerals, there is royalty in whatever name you may call. You may call it cess, you may call it surcharge. The government is earning some revenue from minerals in whatever name it may be called. If the government is already earning royalty from minerals, why should there be another additional tax that amounts to double taxation? Which means mining companies will have to pay. And please note, once mining companies start paying the same government, which is state government, please note, royalty is levied by the central government, but it goes entirely to the state governments. Now, why is the central government levying it? Because there should not be state level disparities on minerals. That is what is the design of the law. And that is the design of all such entries in the Constitution. These are the entries that were actually litigated. So it is a cooperative but combative mode has actually come in. Now, interestingly, Justice Nagaratna's opinion becomes so relevant for many reasons. First, if you apply royalty and tax to minerals, where are these minerals going? Take the example of coal. If coal is having royalty plus tax, they go to thermal power stations. From thermal power stations, you are given electricity. So please note, finally, consumers will pay more because there is 2 levels of taxation on coal. You take iron ore, finally it goes to steel. Then if you're buying steel, you're actually paying already 2 levels of taxes to the same government. Which government? The state governments. But the 8 judges who decided, and that includes Justice Chandrachud, and there was a very interesting observation that the son overruled the father. Yes, the MADA judgment is very well known for that, because the son overruled a judgment of his father, right? The senior Chandrachud. But the point is, the 8 judges said that state governments have the right to tax. Now, which entry do you think they would have read to come to that conclusion. Entry 50 lists 2. So please note, you have list 1, which talks about regulation of mines, which is central government. See, very interesting. Regulation of mines can be done by central government, but tax on minerals can be done by beautiful Constitution of India. Central government has no power to tax. They can only regulate. The word tax is missing. Only regulation is at present. So state governments can only tax, but central governments can probably regulate the taxation. Now, the interesting point in the MADA judgment, which has not been addressed, is please read entry 50, which says taxes on mineral rights, please read it very carefully. This is where attention is required by lawyers, subject to any limitation imposed by the parliament. So Justice Nagaratna says states don't have independent right to impose tax. It is subject to the limitation of the parliament, which means taxes can be imposed, no doubt, by the states, but finally subject to the limitation imposed by the parliament. So we have a federal structure strengthening fiscal federalism, centralizing the right to tax minerals is something to be decided by the parliament alone and not by individual states. Now, why should the parliament decide this? Is because you want uniformity in the country. You don't want Karnataka to have one rate of tax, Jharkhand to have X rate of tax. You know why? Because minerals, friends, come under the doctrine of public trust. It is not individually owned by the states. It is collectively owned by we the people, the Constitution of India. All of us jointly own these minerals, despite the fact that those minerals are present in Jharkhand. Despite the fact it may be present in Odisha. It is not just the Odisha government's right to extract and impose. It is the Indian Constitution's right to extract and impose. So the founders of the Constitution had a great vision. And that gets reflected in this 8-1 judgment, friends, beautifully. Otherwise, just imagine if every state government said, this is my mineral, I will decide what to tax, whether to extract or not, I will decide. Then we would have been in a very difficult situation in the Constitution of India. So the MADA judgment is a very important and an interesting one, but unfortunately, it has faulted, is what Justice Nagaratna thinks. She has gone on to say that the minerals as resources belong to the entire nation. And the limitation of the parliament here in entry 50 clearly means that the parliament can finally decide what should be the nature of tax. Should it be tax? Should it be duties? Should it be cess? Should it be surcharge? Or should it be in the nature of royalty? Parliament has the final say on the same. State governments cannot impose their own independent taxation on minerals. She says the majority opinion can actually affect developmental projects and works in India. She wants it. She says it threatens federalism. Please note that is a very interesting paragraph of Justice Nagaratna. She says no, federalism has to be strengthened. It cannot be weakened by giving states independent right and autonomy to tax. And developmental will definitely get affected if the state governments are given that kind of an autonomy by reading the other list and entry in the Constitution of India. So the curity petition is before the court, and out of the 8 judges who gave this first judgment, 3 are still in the Supreme Court. I'm sure the case will not go before them. It will go before a fresh bench of the court. And let's hope to see a strengthening of fiscal federalism through a curity petition in the Supreme Court. Thank you very much.
Thank you so much, Professor Saram Bhatt, for giving such a beautiful exposition of such a complicated situation, an issue and a very relevant question on which our fiscal federalism's future will be depending in your own original and very interesting style of engaging the audience. Now I invite Professor Atmaram Salekesar for his presentation and observations.
Can somebody change the slide? Okay, honorable expert and chair on the dais and expert of the dais, my friend Yogesh and co-learners. Thank you for calling me. So my presentation is divided in 2 parts. First, we'll have brief explanation or discussion on the provisions. Very brief explanation. Then we'll go to the problem. At least 5 to 6 problem I have stated. Sir has raised the problem with respect to minerals and how central is controlling, state is controlling, what Supreme Court is stating, etc. So similar kind of problems are stated in my presentation also. So this is the scheme of presentation, but I'll be very brief. So in between, if there is question with respect to point number 1 to 9, kindly feel free to ask. We'll spend little more time on point number 10, that is challenges and way forward. Only few fundamental judgments are covered, 3 to 4. Other judgments are not covered in my PPT. So if you'll see the scheme, there is a separate chapter and cooperative federalism and everything you know. But what do you mean by cooperative? Less competition, we can understand in a very simple word. But who has to cooperate with whom? Whether two states has to cooperate, the Maharashtra's or Karnataka's some material is going to the another state, but their government is another government. Here BJP, for hypothetical example, there it is Congress. They will stop material, they will send it to another neighboring state. Whether they are bound to cooperate with respect to this. And for minerals, at least sir has raised that question. Some, this one limitation can be put up by the parliament. But in parliament also there is BJP. They've listened to the Karnataka state with same government, so politics will go on. So in that situation, what to do? So where to cooperate? So if you see the scheme of cooperation per se, or even Supreme Court judgment with respect to cooperative federalism, court time and again stated, and it is reflected in the entire constitution, that they have to cooperate to achieve the objectives of the constitution. Starting with preamble, sir has refer 141, but I want to refer 142. Supreme Court's power to deliver complete justice. Read with Article 129 also. Definitely, law is binding, no doubt about it. And then we have to see the strength of the or majority, etc. But what they have to do, they have to deliver the justice. In the context of taxation also, otherwise also, they are bound to deliver justice. Court clarified that it is not power to deliver justice, it is duty to deliver justice. So power word is interpreted as duty of the Supreme Court of India. Otherwise, duty is not even reflected under 32, clause number 2, or in 131, dispute between two states or central and state. And this matter will fall there, original jurisdiction of the Supreme Court of India. Or if it is connected somehow with fundamental right of individual, it may go under power of 32, clause 2. Supreme Court shall have power to, what is the power? 32. Supreme Court shall have power to writ. But it is not only writ. Issue direction, order and writ including in the nature of 5 kinds of writs are there. So they can do lot of things. Read with Article 142 for the purpose of this also. So in brief, we'll discuss what Supreme Court has done and what are the original provision of the Constitution. So we are having chapter or part number 12, articles 164 to 3 and but all are not dealing. Up to 69 are dealing with your federal and your power to impose tax, etc. So first chapter in that is dealing with general provision, which is related to consolidated fund and contingency fund. Emergency fund required, consolidated fund required for some purposes. Like even salary of the Supreme Court is paid out of that. Then we are having chapter 2, which is dealing with borrowing. Sir has referred little bit about borrowing and limitation, and we have special case with respect to that, wherein borrowing power was reduced. Normally it is discretion, and case is pending before the Supreme Court of India with respect to that. Then discretionary power, granting aid power is also there. That is chapter number 3 in that. So it is read with schedule number 7, wherein sir was referring list number 1, list number 2, list number 3 are given. Now, what is there in this list? It is reflected in the PPT also. Later on also you can study. So in the first list, that is union list, initially less power, but more control. Less power to impose the taxation, but more control on imposition of taxation. Sir also has mentioned the same thing. So initially it was covering customs, income tax, corporate tax, excise duties, etc., on goods and services. Then in the list number 2, 62 entries related to taxation, It covers land revenue, state exercise, stamp duty, entertainment tax, and other taxes are there. Little bit things are there in the concurrent list also for limited purpose. On some of the documents, etc., in concurrent list also, some taxation can be imposed. Now, sir has mentioned in the context of one problem only that tax can be imposed sometime by the central, but actual benefit is taken by the state. And that is seen in entire scheme. Like you people refer 268, tax on the bill of exchange and check, etc. It is collected by union, appropriated by the state. So I'll do, but you utilize. That is the question over here in order to balance the power between central and the state government. Because we don't have pure federalism. Court has used cooperative federalism later on, which is not reflected in the constitution scheme per se. Then there are some provision wherein tax is collected by the central and it is assigned, given to the state. I'll collect and it will be given to you. You don't have to trouble yourself to make legislation to collect the taxation also. Example, interstate trade. We have taken the example of politics. If it is done, what is the justice to another state? Because that state or industry in that state may be depend upon the resources which are available, which are normally part of the India at large per se. Then sometime, if you will see the Article 169, which is later on added and therefore capital A, 101 amendment to the Constitution, again interstate trade and related to GST, etc. And then distribution between state and centrals, Article 270 is there. It is related to income tax, except this one, agriculture. And then we have 271, which is related to surcharge. Sir has mentioned the term surcharge, and this is area to discuss, or this is area which is subject to criticism. A lot of people have written it because there is a lot of discretion and it is not shareable, divided between central and state, irrespective whatever may be comment made by the Finance Commission. So this area is not following under the power of the Finance Commission. If you'll see some year, and I have quoted it later on also, almost 11% goes in surplus or surcharge. So these are the lists. I'll not read because we'll go to the problem later on. So in the state list, 1, 2, 3, 4 things are there, and there are principles to be applied. Sometime, and that is one of the suggestions suggested later on in the light of 276, there is cap given. Whether there can be same cap on the surcharge also, or whether it shall be discretion of the commission, and whether that commission is partially or fully controlled by someone. And if it is not, whether it is objectively reflected or all concern are objectively reflected in all commission report or not, that is different matter or subject to study. Maybe somebody who is interested can take that part and it can be studied later on. These are the just section article mentioned for the purpose of your understanding. But people see the what commission is covering in order to decide distribution of tax, which is horizontal, not based vertical and horizontal taxations are there. So based on need of particular state, you may have particular action, which is vertical action. Horizontal, you'll think about all state, entire population, and for that purpose, some criteria is utilized. That also include population, area, forest ecology, economic distance between two states, etc. And all these things, tax effort taken by the state are considered. Are these right criteria to be utilized? Or whether we should require something else? Maybe per capita income is not found here. Education level of the population is not found here. Need indirectly is reflected in discretionary fund also. But who will decide need? It is not objectively decided based on objective criteria. And therefore, party politics will go on. Party politics will go on. If you see the recommendation of commission also, we are having the Finance Commission, which will give recommendation, which will be appointed for 5 years, etc. Article 280. So recently in 16 Finance Commission, 40%, 41%, not even 50, shares shall be given to the state. The remaining will be taken by the central. Central is doing a lot of project based on that, because some fund cannot be challenged, some can be given in the aid, and there may be limitation on that. Some is discretionary fund utilized, and some fund is utilized by the central government for their own purpose. So they want to decide, put something related to railway, and they will decide the state, irrespective of need, irrespective of whatever may be recommendation by any committee, commission, etc. So that is another problem which is faced in India. So there are statutory and discretionary grant we were discussing previously also, which can be considered. In case of discretion, for anything which is related to public purpose, not even welfare, for the public purpose, this discretionary fund can be utilized. So if they are having same government, everything for them is public purpose, which is not well defined also. So in X state, there are roads and everything is there. They will say, no, more road, more railways, more everything for the public purpose. In another state, that facilities are not there. They will not see that as public purpose for discretionary fund. And here again, party politics will go on. So similar section and little bit about amendment I had covered along with case laws, but we'll go to the this one, a problem directly. So it will save little time also. So we are having case like Mohit Minerals case 2022. Court has clarified, because this financial commission, which is giving recommendation to distribute fund between central and state, is only the statutory body. They are not legislative body. In that sense, they are not quasi-judicial body also. So court said their judgment, their recommendation are persuasive in nature, not binding on the parliament. They are following, but they don't want to follow. They may not follow also. So in the scheme of constitution, it is not clear. And later on also in amendment, it is not clear. And court has clarified that they cannot deal with cooperative federalism. That shall be through deliberation between central and states, not through the recommendation given by the Financial Commission. So that is one problem. Second, many times this government, central government, that is parliament, is going here and there. There is second case, West Bengal versus Kasoram industry. Their court has held that they can go here and there. Pith and substance doctrine can be applied for that purpose. So major objective shall be seen. Allied objective can go here and there, even beyond legislative capacity, which is recognized under the Constitution of India. So this judgment, like sir was stating, there are many judgments, but justice is delivered in few only, is not connected, not read with power and duties of the Supreme Court under Article 142, right or duty to deliver complete justice. And even with the preamble, wherein justice part is there, social, economical, and political justice. For social justice also money is required. Definitely for economic justice, this distribution is required. And for a lot of other welfare things, justice is required, money is required. So that court has not observed in these things. Then in Jindal case also court said it is many times it is discretion of the central government to impose the taxation, etc. So there is no clear-cut guidelines given. And then S.R. Boumai, everybody is aware about. Very famous case on federalism, cooperative federalism. Their court said federalism is a basic structure. So lot of things with respect to federalism cannot be easily altered by the parliament, even with 2/3 majority and assent of the half of the state. In GST also, consent of or assent of the half of the state was taken while amending, that is 101 amendment to the Constitution of India. Now, these are 4 or 5 problems which are raised for the discussion. Definitely other problems are there. Sir has touched 1 or 2 problems. One is related to sharing the revenue, vertical fiscal imbalance. Their proportionality based on anything which is doctrine under 14 and which is ultimately our right in general also and in particular also. So it is right of state people in general and right of individual in particular. So that is not followed. So what is happening? 62% is going to union, and out of that even up to 20% they can utilize with full discretion, and 41 is given to the state. But from where money is coming? What is the state territory? Whether there is central territory, there are Delhi, etc., recognized as central territories, but they are state territories actually. So state is earning nothing. There are no minerals with the state. There are no industries with the central government. They are getting everything from the states only, and they are utilizing up to 62%. That is problem number one. Problem number two is about the discretionary fund spent and central government with logic, without logic, for the political purpose or otherwise. And politics plays behind with respect to this. Surcharge problem already discussed by the sir also. Initially, we have discussed that this money will go, which is not divided. If you see the recent data, 2025 and 26, 11% money had gone into surcharge, which is very high amount for the central government. So they will decide everything. And then sometime, many time rather, party politics will be played because we are multi-party system. So a lot of people are discussing, arguing that in central BJP is there, in state you can vote for same, so benefit from central will come to the state. So what about right to vote, which is also fundamental right, are connected with Article 21? Because it is causing burden. It is not free choice of the individual. Choice is subject to lot of condition. One of the condition is that central has some government or people in power or party in power, irrespective of parties, and they will support the state, at least in this percentage, to that state only if their own government is chosen by the people. So it is violating not only cooperative federalism, but also democracy or right to democracy or free choice in the democracy. And that is not even deliberated by the court anywhere, or deliberated, some expert must have been, but by the court till today. Then with respect to horizontal equity also, some criteria is considered by the Finance Commission. Like 15 Finance Commission, if you see, it is very restricted purpose they have applied, or criteria or parameter they have applied. What they have applied? Prioritizing fiscal equity. It is not equality. It is equity word, which is different from, or rather larger than, right of equality, which is good point to be referred, and the performance, that is demographic performance and need. So again, for the purpose of need, definitely in GST, state people are taken into consideration, not for the central purpose or for this recommendation. They will not call, they will not discuss, they will not deliberate it. They are expert and they will decide. Number of people will decide. But they will not ask to particular state, what is your need? You give us the need, we'll deliberate on that, we'll give you time to justify your need, and based on that, our decision is taken. So small state may not able to represent in parliament also and otherwise before this commission, committee, etc. Last point which is there, that is discretionary fund and borrowing is another problem. There, lot of politics can play. Because while borrowing, it is a borrower who will decide to borrow, but central government will decide whether money shall be given or not, or whether there shall be limitation. Case I refer is pending with respect to borrowing, and it is reduced up to some extent. So that is another problem. Discretionary fund is one problem we have discussed previously. So discretionary word, you know, in law for utilization of discretion, some generic parameters are there. Here, there is no limitation put upon the central government. So definitely there shall be cooperative federalism. We have to understand the cooperative federalism. We have to understand parameter required for the cooperative federalism. It shall include the objectives ought to be achieved by the Constitution. That shall be cooperation to achieve that objective and not for party or politics, etc. Nowhere it is clearly stated in no document, even in the Constitution, that you fight for three objectives. It is justice, social, spend some money for that. So you find out the state which is socially backward, spend money over there. Educationally backward, economically backward state, you find out, and that will come under need in general, but that is not specified. So it shall be in accordance to entire scheme of the Constitution. The Supreme Court has to deliberate their duty under 142, that is duty to deliver complete justice to everybody, to each state. Now if you do so, there is another problem, and which is raised by many states in between. They are saying that Mumbai or some state are contributing more. Other states are contributing less. We are giving more, but we are receiving less, and therefore there shall be balance. So this is the point of controversy. This is point for deliberation. This is point for discussion. So whether there can be cap that you give this and this, out of that 5% will be given to you, 5% extra, and remaining will be given based on the parameter that may be need, that may be justice to be delivered in accordance with the preamble or other provision of the Constitution of India. Okay, so that was from my side. If there is a specific question, that can be deliberated. In way forward, quickly I'll read out. First, on surcharge, there shall be cap, specific cap. Like in other things, professional tax. Sir is aware there is cap. Central state government cannot increase beyond that cap. So that shall be reflected over there. We are having GST council and even state representation is also there. But there is no transparency in the decision making. We'll not come to know what had happened, where it had happened, and why it had happened. So that is another thing. There is need to rationalize the sponsor scheme by the central, including aids and other schemes. There shall be more power given to the Finance Commission, and they shall have the permanent secretariat. So people can approach, more deliberation, more smooth functioning can happen. And ultimately, definitely, we have to promote cooperative federalism. That part, I think every expert has spoken about. So thank you. These were the points from my side. Thank you for your patient listening. And I thank management of KLE Law College and my friend Yogesh also for calling and giving chance to discuss with you. Thank you so much.
So, thank you, Professor Atmanam Saleke sir, for making such elaborate and wonderful exposition of the current, not only the legal framework, the controversies, as well as what is the possible way forward that we are looking at. And meanwhile, when I was listening to sir, I just checked. Actually, this 9-bench, I shared with Professor Bhatt is 26 July, from which the court will hear. So as he very correctly said, that what is Supreme Court deciding? So now Supreme Court, all these 9 benches are, one after other, looking only review of the earlier judgments. Right now they are sitting on the decision of the Sabrimala. Before that we had the Bangalore water supply. So, but that's good. Judicial process will need to progress with society. So with reserving my concluding remarks at the end, I would now like to open about 5 minutes. So about 2 to 3 questions we can take shortly to our experts. Please, if anyone is interested to ask questions, please also point out to which expert you wish the expert to answer, which of the 2 experts. So please specify that along with your questions. No? Okay. So yeah, so Professor Menon at times used to say that before lunch it is always that do not hold them too long, because a hungry person is an angry person, so you don't want to increase the anger. So anyway, it was a great, for me also, like all of you sitting here, it was a great learning experience. As I said at the very beginning, this is not the area that I have very minuscule understanding. So it was a great learning experience. Both of the professors and with their expertise and in their individual style provided a beautiful, exposition of a very, very complicated area. And at least by end of this, half an hour to 45 minutes discussion that we heard, at least for me, it was extremely enriching, because I have now some clarity about the constitutional position, about the judicial decisions, about the controversies, and what is possibly the way future looks at this. One thing that I think is, the three models that Professor Bhatt, Saram Bhatt started with, docile, combative and cooperative. Of course, the first one, I think it's very rare to get, although we are talking about double engine governments. But even there also, I think it would be very difficult to go back to a state where we'll have a docile federalistic model, at least in the fiscal area. But to combative to cooperative, there, I think lawyers and judiciary will have to and policymakers have to play a major role to ensure that the constitutional vision should not be lost at any point of time, and the governance should already our honorable justice had made this wonderful statement that tax collection is like collection of honey by a honeybee from the flower. I think that should be the spirit that should always govern us when we are young law students or young legal scholars, when we work in the field of taxation or fiscal federalism. And with this words, I thank all of you, and I also thank the organizers of this conference to provide me an opportunity to, rather than share anything, learn more. And it was a great learning session. Thank you very much.
Respected Chair, distinguished speakers, respected faculty members, and dear participants, on behalf of KLE Law College, Bengaluru, I express my sincere gratitude to our esteemed Chair, Professor Anirban Chakravarti, sir. I also extend my heartfelt thanks to our distinguished speakers, Dr. Atmaram Shelke and Dr. Sairam Bhatt, sir, for their enlightening and insightful deliberations on this important theme. Your contributions have greatly enriched our understanding of the constitutional framework governing the fiscal federalism. I would also like to express my deep sense of gratitude to our principal, Professor J. Mallikarjunaya sir, for his constant support and encouragement. I also thank the organizing committee, faculty members, and participants for their active presence and engagement. With this, I conclude the plenary session too. Thank you.
Principal
Tanmay? Anybody from AV room, please respond.